Support for this podcast is provided by Avalara. Since 2004, Avalara's vision has been to harness the power of cloud technology to simplify sales taxes for businesses of all sizes and to affordably scale with them as they grow. Collecting taxes is just one of those things a business has to do, so getting it done efficiently and correctly can be a challenge, especially with rules and regulations that can be endlessly complicated. For example, did you know that in New York, a bagel is tax-free, but once you slice it and add a schmear, it's taxable? Avalara keeps track of these things so that you can focus on your business, whether or not it involves bagels. If you deal with tax compliance and you've thought to yourself, there must be a better way, then do yourself a favor and check them out at avalara.com/taxnotes. That's avalara.com/taxnotes. Avalara. Tax compliance done right.
Welcome to Tax Notes Talk, a podcast from Tax Notes, the leading source of tax news, information, and analysis.
Welcome to the podcast. I'm David Stewart, Editor-in-Chief of Tax Notes Today International. This week, catching up with the Chief Judge. Maurice Foley began his second term as Chief Judge of the U.S. Tax Court this year under somewhat trying circumstances. In March, the court closed its doors and pivoted to virtual hearings as the country grappled with the first wave of the coronavirus pandemic. And now, the tax court is working through one of its biggest technological projects yet, updating its online case management system. Here to talk more about the changes of the court under Judge Foley is Tax Notes legal reporter Nathan Richman. Nate, welcome back to the podcast.
Thanks for having me, Dave.
I understand you recently talked to Chief Judge Foley, but before we get into that, could you give us a little bit of background on the judge?
Well, when his nomination was confirmed in 1995, Judge Foley became the first Black tax court judge. Before that, he worked at the Treasury Department, the Senate Finance Committee, and the IRS Office of Chief Counsel.
Now, as I mentioned a bit earlier, Foley is now a few months into his second term as Chief Judge of the U.S. Tax Court. What does the role of Chief Judge consist of, and how is the position filled?
The Chief Judge handles a variety of administrative duties around the court, things like handling motions and orders in cases before they've been assigned to specific judges. That doesn't happen for the most part until a case is scheduled for a trial session. And the Chief Judge is picked by the voting tax court judges. Those are the judges who are serving the 15-year terms after having been approved by the Senate. So not the senior judges, not the special trial judges. They all vote for a new chief judge every 2 years.
Just before we get to this interview, could you tell us a bit about what you talked about?
So we chatted a bit about his background and journey to the court, and then we discussed those two big issues going on at the court right now that you mentioned, the tax court's new case management system and the remote proceedings it's conducting in light of the pandemic. For about the last 18 months or so, we've been hearing that the tax court wants to update its system for handling all of the documents filed in its various cases. The system it was working on had been developed in the 1980s. And the court is finally starting the transition to the new system, which will finally allow taxpayers to file their petitions electronically. And speaking of electronically, like so many others during the pandemic, the court had to come up with a way to conduct its business while social distancing. The court's solution was to conduct all of its trials and other hearings via video conferencing software. But interestingly, Judge Foley noted that many of these tools and techniques that the court's been employing for the pandemic could help better serve the various litigants, petitioners, IRS, and all the people involved with the court after we finally get back to normal.
All right, let's go to that interview.
Well, thank you for joining us, Judge Foley. Pleasure to have you.
It's a pleasure to be here, Nathan.
You were appointed to the tax court after serving in the federal government for several years. Can you just share your journey to the court with us?
I became interested in tax when I was in college, and I was studying economics and poli-sci. I had a concentration in public policy and Black studies. And in my junior year of college, I took a macroeconomic policy class that was team taught by someone from the poli-sci department and an economics professor. And during that class, for about a week, they talked about tax policy and tax incentives. And at that point, I really realized that tax policy was an amalgamation of all of the things that I really kind of cherished and that I was studying. So I discovered that tax policy was really the nexus between economics and politics. And it also involved a heavy element of public policy. So during this class, we studied enterprise zones, which at the time was just a fledgling concept. It had been tried in England, and some of the states were starting to adopt it, and the federal government was just beginning to explore it. That really fascinated me, and it actually gave me an incentive to become a tax attorney. So at that point, I didn't know much about tax, and I talked to my professor who was teaching the class, he was a poli-sci professor, but he was formerly a businessman, and he pointed me to a tax case that he actually had when he was in business back in the 60s. And curiously enough, his tax attorney was Ted Tannenwald, who actually served on the court, and I had the pleasure of serving with him many years later. But at the time, I was a 20-year-old looking at this tax court case that was actually a 482 case.
First court case you ever looked at?
Absolutely, the first court case I ever looked at, and little did I know that a couple decades later I'd be going through 482 again and dealing with cases like Xilinx and Veritas and so forth. But I was at age 20, I was looking at this tax court case, learning about the tax court for the first time. And as I kind of tracked through the progression of this case, I realized that Ted Tannenwald, before the case went to tax court, he was appointed to the tax court, and a new attorney was assigned to his case, and that was Marty Ginsburg. So my tax professor knew a little bit about tax, and he also knew a little bit about what it would take to be a really good tax attorney. So at that point, I began to consult with him and talk to him about what I needed to do to become a tax attorney. And at the time, I had planned to go into law. I wasn't real sure about what area of the law, but I was now sure that tax policy was the route I wanted to take. And he began to prepare me and point me in the right direction. So while I was in college, I actually talked to tax attorneys, practicing tax attorneys, to get an idea of what I had to do in order to prepare myself. So I decided as a junior in college that I was going to go to law school, and then after law school get an LLM in taxation. And originally I was going to go to law school and get an MBA. But after talking to people who were practicing in the field, they said, well, if you really want to practice tax law, you don't need to get an MBA where you learn accounting and marketing and finance. And I certainly wasn't interested in those. I just wanted to learn tax. After college, I went to law school. I suffered through the first year of law school with crim law and torts and contracts and civil procedure and all of those evidence. And I longed to take my tax classes. And in my second year, I was able to start taking tax classes, and actually worked for a nonprofit law firm while at Berkeley, doing some tax work for community development corporations and things like that. Because I always had this interest in how the tax code could be used to do some of these social things that I had read about when I was studying economics at Swarthmore. While I was at Berkeley, I did a paper that dealt with, as strange as it seems, I still have the paper. I was looking at it the other day, and I was dealing with these, the substantial economic effect of certain allocations to limited partners. I was looking at the 704B regulations, and I said, boy, I must have been a really sick individual to in law school to be looking at that stuff. But while I was looking at those regulations, there was a part of the regulations that and it's included in a lot of the regulations, where it says, for further information, contact Joe Smith at 1111 Constitution Avenue and Washington, D.C. And when I saw that, and after reading the regulations, I said, that's what I want to do. I want to be the guy who has a sufficient amount of technical expertise to write the regulations. And I went to the career office. They had this little binder of jobs that were in the chief counsel's office, and I said, this is what I want to do. I discovered that there was a division of the IRS called the Legislation and Regulations Division, and interviewed for that job, and received a recommendation by my interviewer to go directly to the Legislation and Regulations Division, and that's where I started. That's where I started my career. But at this point, the plan had been in place for a while, and I was thinking that I was going to use my tax expertise to do tax planning for athletes and entertainers. And I had this master plan where I was going to, set up their private foundations and their charitable organizations, and that's how I was going to satisfy my desire to have an impact on communities that I really cared about. So I went to work for the IRS in the Legislation and Regulations Division. I was in the Transfer Tax Division, and no, that's not international. That's not an international tax.
No, that's a gift and estate, right?
Absolutely. And also excise taxes. So for the first 6 or 7 months, I worked on excise taxes and the section 4051, the retail tax on heavy trucks. I drafted regulations in that area. And of course, if I had to do that for more than 6 or 7 months, I probably wouldn't be here now, because I probably would have blown my brains out, because it was not very exciting, but it was really good training for me. And in 1980, so I started in 1985, and in 1986, of course, there was tax reform, and we had a meeting in our branch, and our branch chief asked if anyone would be interested in doing the regulations for the generation skipping transfer tax, and nobody raised their hand. So I raised my hand because I was interested. And in 1986, the generation skipping transfer tax was expanded to include direct skips, and there hadn't been any regulations, of course, drafted on that. So I wrote the temporary regulations relating to the modifications in the generation skipping transfer tax. And that was a fascinating experience for me, because I was responsible for drafting these brand new rules and became an expert in the area. So I was traveling around the country doing these CLEs and ABA events, and also working with IRS agents to kind of show them how the rules work.
Is that one of the temporary regs that's still around?
I believe it is. I believe that. I haven't gone back to look at it, but I think they're probably still around. And it was just a fascinating experience, because I was constantly fielding calls from the public as they were working on the rules, and they had questions, and they would call me with the questions, and it gave me an opportunity to really dig really deep into the rules, and to find out where I needed to develop regulation. So that was really a critical part of my development, because it really taught me the importance of writing carefully. I discovered that if you put a comma in the wrong place, it can change the entire meaning of a sentence, and have proper placement of clauses, and all of that became a high priority. So I really had to focus on the written word, and I had to be concise, I had to be to the point, and I had to be careful. So that was a really important training for me, and little did I know it was good training for what I would later be doing. The other thing about my experience at the IRS is that while I was drafting regulations, I also had the opportunity for the first time to be exposed to the legislative process. And at the time, whenever the folks on the Hill were drafting legislation, they would always call up someone from the IRS to sit in on the drafting sessions. So immediately after the 86 Act, they began drafting the technical corrections for the 86 Act. And as you might suspect, there were a lot of technical corrections for the generation skipping transfer tax. So I had an opportunity to go up on the Hill and sit in on those meetings, and that just opened up a whole new world for me, because in sitting in on those meetings, after a brief exchange of pleasantries, they devolved into this kind of an amazing, very fascinating discussion that involved all these regulations, cross references to different code sections, and citations to various regulations, and somebody would go on the board and kind of sketch out what transactions they wanted to include and what things they wanted to exclude. And that just opened up a whole new world for me, and I became fascinated with the legislative process. And I was able to kind of bring in some of the questions that I had with the about the rules, and then watch them develop technical corrections to address some of these issues. So I was hooked at that point. I was definitely poised and ready to delve into the policy world. So I worked at the IRS for about 2.5 years, and I actually was starting to look for a job in California, and I was all set to fulfill my dream to go out and start practicing tax law for these athletes and entertainers. And I was actually at my desk working on my resume to send to a headhunter out in California when I got a call from the chief tax counsel of the Senate Finance Committee, and asked me if I would be interested in working there. This was on a Wednesday. He asked me if I could have my resume by Monday. I wanted to tell him I could have it to you today if you'd like it, but I didn't want to seem too anxious. So I sent it to him that Friday. Ended up getting a job at the Senate Finance Committee, which was interesting because it was just about the time when I had finished my LLM. So I had spent 2.5 years very narrowly focused on a Chapter 13. And then I went to the Senate Finance Committee, and I was given just really broad jurisdiction over a lot of things. So when I went to the Finance Committee, I had jurisdiction over a lot more than just the generation skipping transfer tax.
Did you take gift and estate tax as a JD or as part of your LLM?
I took it as a JD, and it was actually the tax class that I liked the most. It had a really very, very exciting professor, and he was very charismatic and entertaining, and he made estate tax fascinating. And indeed, he was such a good teacher that I took a class that he taught on future interest, and there were only about 2 or 3 people in the class, but we learned all about dynasty trust and the rule of perpetuities and these very complex intergenerational transfers and things like that. But the estate and gift tax is really what caught my eye early on as I was studying tax in law school. So when I got to the Finance Committee, in addition to estate and gift tax, which I was basically hired to deal with the estate and gift tax. So there were some issues with respect to a provision in Section 2036. 2036C had an estate freeze provisions that were causing a lot of consternation, and the Senate was very interested in modifying those rules. So I was hired to take a close look at that and see what could be drafted as an alternative. But I also had responsibility for all the individual tax items, exempt organizations, cost recovery, penalties, research credit, low-income housing credit, earned income tax credit. As the low man on the totem pole, I got what everybody else didn't want. So there were other individuals who handled corporate tax, international tax, employee plans, and also energy tax incentives. I worked for Lloyd Benson. He was chairman of the Senate Finance Committee, and if you work for the senior senator from Texas, you soon realize that all energy tax incentives are a matter of national security. So I was not assigned to that, but I was assigned to a very broad range of tax provisions, and it really was an exciting time for me because I was able to delve into a lot of areas that I knew nothing about.
And if you're working on R&D, that means a bill every other year, right?
Absolutely. At that time, the R&D credit wasn't permanent. So every single year there was a bill to extend it, and every single year there was a letter that was sent that was, almost every senator had signed on to it, that kind of pushing for it to be permanent, and also most of Congress was in favor of it being permanent. But each year we never had the funds. Congress never had the funds to actually make it permanent, but eventually they did. So it was a very interesting time for me, and one of the things that made it interesting is I was also able to work on things like the earned income tax credit, which I had studied in college, and at the time when I was studying, it was just a kind of a $500 a year program, and of course now we have a maximum credit of almost $7,000, and I was able to really participate in my career over the kind of dramatic growth and some of the significant changes in the credit that occurred over the time that I was on the Hill and at the Treasury Department. So work at the Finance Committee was great. I eventually did work on a bill that repealed Section 2036C and replaced it with Chapter 14. So I worked on the Chapter 14 valuation rules, Section 2701 through 2704, that were the valuation rules that replaced Section 2036C. And I worked on a bill that was sponsored by Senator Benson, and eventually we came up with a compromise with the House, and what the ultimate result is the Chapter 14 that we have today. So that was fascinating. That was interesting. And I also had an opportunity while I was at the Finance Committee, in the year before I left, we worked on a bill that included enterprise zones. The bill didn't get passed. It was pocket vetoed because it was an election year. But at the end of 1992, I was again interested in leaving the government and doing something else. And I was going to go into the private sector. And at the time, my boss was the first cabinet pick by President Clinton. And then at that point, I decided I was going to go to the Treasury Department and work there. So after about 5 years at the Senate Finance Committee, I went to the Treasury Department, and that again opened up a whole new world for me, because I was able to work on legislation. They created a new position. I was not interested in doing any regulations at that point. I was pretty burnt out from my years working on the generation skipping transfer tax. So I wanted to work in the tax legislative counsel's office, but I didn't want to do anything dealing with regulations. And they said, well, that job doesn't exist. So they created a new job, the deputy tax legislative counsel for legislation. And I was the first person in that position. And it allowed me to basically do a lot of the things that I was doing at the Senate Finance Committee. I was put on a couple of task forces that I just found fascinating. I was put on the welfare reform task force. I was the tax nerd on the task force. It included all these specialists in income securities, a lot of folks from former professors at the Kennedy School, and they knew a lot about welfare reform, which I knew nothing about, but I knew a lot about the earned income tax credit, and that was a critical part of the administration's welfare reform proposal, because their intention was to put time limitations on the program, and in order to ensure that people were able to get above the poverty level with a minimum wage job, it was necessary for there to be a dramatic increase in the credit, because we looked at the data and it was possible to work full time and receive food stamps and still be below the poverty level. And the earned income tax credit was about $800 at that time, and it wasn't sufficient to boost somebody above the poverty level. So the president made it very clear early on in his administration that one of the important things in his budget bill would be a dramatic increase in the EITC. So I worked very hard on that with Treasury economists and designing how that would happen.
So that's one of these big steps in what we hear now about how much more so the IRS is the social support agency as well as the revenue agency, after what I can't recall who administered, was it AFDC?
Yes. Yeah. It was AFDC at that time. Before it was after the change in 93, I believe it was. It became the Temporary Assistance for Needy Families, TANF. But in making that change, the expansion of the earned income tax credit was critical, and it's now one of probably the most successful government anti-poverty program, taking millions of people, primarily children, out of poverty. So that was a lot of fun working on that, because the way the administration was set up, for the first time they set up the National Economic Council and the Domestic Policy Council. The National Economic Council was set up to coordinate all economic policy for the administration, and the Domestic Policy Council was to coordinate domestic policy. And they had a kind of a joint task force for various priorities that the president had. And one of them, of course, was welfare reform. And the other priority and a task force that I served on was to develop enterprise zones, called empowerment zones at the time. So it's just always been fascinating to me to when I reflect back on my career and I realize that the tax provision or the tax proposal, a concept that really incentivized me to become a tax attorney, 12 years later, I was blessed to be in a position where I could actually design the tax rules that would be part of the first federal government program in that area.
With all the changing names over time, are you now working on a tax court committee for dealing with opportunity zones?
No, not yet. We haven't had to face opportunity zones yet, but it has been interesting watching the development of that of that area of the law. These place-based tax incentives were kind of a new thing in the 90s, and empowerment zones were really the first significant government program in that area. And indeed, it was a demonstration project. There wasn't a lot of resources devoted to it, but it really set a template for other types of tax provisions that would follow. For example, after empowerment zones, there have been, after 9/11, there were liberty zones that were created in New York. After the hurricanes in the Gulf, there were GO zones or Gulf opportunity zones created. And just recently, we have opportunity zones, which are kind of part of that long line of place-based tax incentives. So I loved my time at the Treasury Department because I was able to work on some things that actually got into the law, and I can look back now and still see a lot of that law that has, some of those things have gone away, but there are some enduring things like the earned income tax credit that's still there and still growing and still providing a lot of assistance to over 25 million people. So I was just blessed to be a part of that. And it was a kind of a fulfillment of my dream as a 20-year-old who was a kind of a tax nerd interested in policy, to have an impact on a lot of communities that I really cared about.
So you were selected as the first Black tax court judge, and now you're in your second term as chief judge. What sort of, or were there any unique challenges in being the first?
Yeah. Well, I was also very blessed in that I was raised to really focus on taking advantage of opportunities. And I grew up in places like Utah, Minot, North Dakota. My dad was in the Air Force. He worked on Minuteman missiles, so he was oftentimes, we were oftentimes located in places that were pretty out of the way and isolated, very remote. So it was not uncommon for me to, growing up, to be the one and only. And I became quite comfortable being the one and only, to the point where it never even dawned on me. But I was raised by parents who emphasized faith and the importance of education. So, while there were obstacles, they were never obstacles that I deemed to be very significant, because I had a priority. I prioritized my faith and the emphasis on education. I knew that, and my father would tell me that with an education and a blessing, anything is possible. And in my life, that's proven to be the case.
Support for this podcast is provided by the University of California Irvine School of Law Graduate Tax Program. If you're hearing this, you're clearly interested in taxes, and you might benefit from checking out our sponsor, or you might know someone who will. The UC Irvine Law School offers a 1-year, full-time program that's been ranked the #1 graduate tax program on the West Coast. Students can expect a unique academic experience that combines in-depth doctrinal work and practical perspective to prepare students for successful careers in tax law. The small student-to-faculty ratio also ensures that students get the attention they need to succeed. Applications are open now. For non-US applications, the deadline is April 1st, 2021. For US-based students, the deadline is July 1st. To apply today, visit law.uci.edu/gradtax. That's law.uci.edu/gradtax.
So there are big things happening at the court at the moment. I hear you're updating your case management system for managing all the documents that are filed at the court. And we've been hearing about this since at least last summer. And that also, this will include the tax court accepting electronic petition filing. What's the latest?
Yeah, well, we're going full steam ahead on the development of our new case management system, which it's going to be called Dawson, named after one of our former judges, Howard Dawson, who was appointed by President Kennedy back in the '60s. Our plan is that we'll have our system online before the end of the year, and we're very, very excited about it. It's going to be a web-based system that's tailor-made for us, and it's going to further facilitate our remote operations and really put us in a position where we're going to be able to really provide much better service to the public, and also it's going to dramatically change the way we're able to access our cases and work internally. So a lot of the work, is not going to be, the public won't even see, but it's going to be a really huge step forward for all of us, and the public will be able to. I think you already have our new website that's out, but in addition, when we go live, the taxpayers and litigants are going to be interfacing with our new case management system, and I think they're going to be very, very happy with it.
So between now and the rollout, actually starting a week or so ago, you froze the electronic filing system as it is. Why was that necessary?
Well, there's a lot of work that has to be done. We had an old system that was developed back in the '80s, and now we're going to a cloud-based system that is dramatically different. So we had to take all of the data and all of the case information and the filings that were in our old system and migrate them to a brand new system. And that's a very, very tedious process that takes a significant amount of time. And at this very moment, all tax court employees are engaged in the process of going through the data that's been migrated to make sure that everything's been migrated and there's nothing missing. That is a tedious process, and it's a process that we can't delegate to contractors because of the nature of the information. So tax court employees are engaged in that process, and that process takes some time, but it's important. We have a very important job, and we want the public to be served well. And in order for them to be served well, there has to be accuracy, and there has to be great care taken to make sure that we haven't left anything out and we haven't made any mistakes. So as you might imagine, when you have a system that was developed in the '80s and wasn't continually updated. I mean, we updated it so that it could run, but when you contrast that with a brand new system that's cloud based,
it's not a one generation upgrade.
It's a quantum leap forward, and it's interesting because I think we're going to be at the forefront of institutions in the government that have done this. So we have gone from being in the dark ages to being at the forefront of the technological development for managing cases.
So ahead of the courts that are on the PACER system.
Absolutely. And like I said, we have a system that's going to be tailor-made for the tax court, and we're going to be in a position because it's all open source material, and we're going to be in a position where we can, as issues pop up, it's an agile software development. So as issues pop up, we're going to be able to develop the software and make changes in the code that are going to allow us to address those changes immediately. And that puts us in a very, very good position for the future.
So just a little bit more on the blackout period. The notice says at the latest December 28th. I read that as at the latest rather than that's your ETA. Is there some sort of sooner ETA, or how far along in the process? Can you update us on that?
Well, we're currently proceeding according to schedule. If of course we get it finished before December 28th, we will go live before December 28th. But December 28th is the date that we've set as the deadline. So that's what we're working toward. If we can do better than the deadline, we will do so. But my emphasis is to make sure that we don't go past the deadline.
What differences will litigants see in the e-filing process? And will anything be changed for somebody who filed one way already and now their case is still open afterwards?
Well, I mean, one of the more significant changes is you'll be able to file petitions electronically. And heretofore we've been limited to filing petitions on paper. So we're going from a paper-based system to one that's almost entirely electronic, and that's significant. And one of the reasons why it's significant is illustrated by the pandemic. And where the pandemic affected everyone, and we had people who were in a position where they couldn't leave their homes and things like that. And in going to a system that's completely electronic, we are putting ourselves in a position where we can deal with things like that. Instances where there are travel restrictions, or because of something that's going on in a particular area, natural disasters or other things that might affect somebody's ability to file a petition. By going completely electronic, we're able to kind of cut through all of that and put us in a position to handle a lot better some of these unforeseen circumstances that have in the past kind of stopped us cold.
Do you have the midnight mailbox alternative rules worked out, or are you still tinkering with what filing by the deadline will mean when every second of the day is available rather than only as soon as the shippers close?
Well, I'm not gonna comment on anything that might potentially be subject of a court case, but we'll certainly follow the statutory rules with respect to the deadlines.
But you aren't going to have new sets of rules or statements about time zones and which midnight matters.
We will have some guidance with respect to that.
So does it matter what time of year it is, whether it's daylight savings time or not?
Nathan, as you know, the court's headquartered in Washington, D.C., so it's going to be based on Eastern time.
What sort of testing did you do on this system? I've seen it demonstrated and heard a lot of the discussion about how it's supposed to be so much more intuitive, easy, and like an Intuit product. But have you, say, had somebody outside the court try to use it? Somebody not tax educated?
Yeah. We've had all the stakeholders participate in the process. So in testing it, we've had average people interface with the system, and we've also had professionals. We've had folks from the clinics, we've had folks from the IRS, we've had folks from the bar to interface with the system and make recommendations. So we wanted to make sure that this is something that is not just accessible, but we wanted it to be something that people could understand and they could be very comfortable with. So one of the biggest changes is that we're the interface that individuals using the system, the interface is going to be much cleaner and much more modern, and it's going to resemble other websites that people interact with every day. Some taxpayers come to our court and they're only there for one time. I mean, they're not frequent flyers, and we want to make it comfortable for them. So we've taken great pains to make sure that just because the tax code is mind-numbingly complex, we don't want someone's interaction with the tax court to be difficult. So we wanted to make sure that pro se taxpayers can access our system easily. And as you know, Nathan, more than 70% of the individuals who have cases in tax court do not have representatives. So we have always put that as a priority to make sure that they have not just access, but that they're able to access it easily and understand it.
Speaking of access, I've been hearing a lot from the IRS, especially on expanding language access, more and more and more languages that forms will be in. Have you done anything like that with the new system?
Well, Nathan, you're really pushing us. We're as I tell my staff all the time, I struggle with the English language, so we haven't explored that. we're trying to focus on making sure that all of the things that we have to do are being communicated well and being communicated clearly, but we're using the English language.
First, to be sure somebody with LITC help can do this.
Absolutely, and that's what the LITCs we have. As you know, we're a national court, trials in 74 different cities, and in all of those cities we have clinics that are available to assist taxpayers, and in most instances those clinics do a very, very good job in helping folks. And we also have interpreters available for people who have language problems, and it's not just at the trial court session, but also if they're in conference calls and things like that prior to the session. We can, arrangements can be made for them to have interpreters who will help them navigate the process.
I'm curious what this will mean for the people who are not the direct litigants. Will some sorts of documents be available differently? Will the court be updating its document posting and release differently for observers, journalists, and people who are interested for preparing their own cases in the future?
I'm not sure I understand the question.
Will there be other sorts of things that the new CMS will involve, posting orders differently, posting opinions differently, other sorts of documents availability?
Well, you'll be able to see all the opinions. You'll be able to see all the orders. You'll be able to see bench opinions. There's going to be no change to electronic access, to our court materials, but orders are going to be served in real time, and we'll have opinions that are going to be released at the end of the day. But one of the advantages of having everything electronic is that we can do things quickly, and we don't have to kind of wait and mail things in batches and that kind of stuff. We can move we have much more flexibility and can move much more efficiently.
So the COVID-19 pandemic has hit us all. Tax court first, of course, had to close its doors and cancel its spring in-person trial sessions. This summer, there's the announcement of remote proceedings, which started mostly in September. So what's different about these remote proceedings? And what sorts of solutions did you have to work through, and what sorts of rules did you have to adjust?
We knew early on in March, after we decided that everything was going to be remote in terms of our staff, and we had to make a lot of changes. But even in March, we realized that we were going to have to significantly change the way that we operated. So one of the first things that we did was set up a working group to start to address all of the issues on remote hearings and trials. And the working group was benefited by all of the experiences of a lot of the state courts, the Michigan State Court, the Texas State Courts, which were far ahead of the federal government in terms of doing things remotely. We even looked at what the Alaska courts were doing, who are constantly faced with geographical challenges that really require a great deal of creativity. And it involved all the stakeholders. So we gathered all the stakeholders together and got the views of the bar and the clinics and the IRS. And what we discovered is that we had some unique challenges, but because we're a national court that typically holds cases, court sessions in 74 different cities, but we also had some unique advantages. And first of all, we don't deal with criminal issues, so we didn't have to worry about juries. The tax court stipulation process, which is the bedrock of tax court litigation, is that's the envy of a lot of courts. The fact that we're able to focus on stipulations and narrow issues and really hone in on legal issues and issues where there's a dispute. That put us in a position where we were really well suited to doing things remotely. And I've been very pleased with how pro se petitioners and IRS counsel and many law firms have embraced these changes. But it's different. It's very different. We're making use of technology, and we're making it work for us. Now, one significant thing about the tax court is we have a statutory mandate under Section 7446 to provide hearings and trials with as little inconvenience and expense to taxpayers as is practicable. That's our statutory mandate to give taxpayers a forum in a way that minimizes their expense and inconvenience. So in a sense, these remote trials are a fulfillment of our statutory mandate. We have instances now where individuals who are on the road, 365 days a year, they can have their trial in a location while they're on the road, and they don't have to come back to a particular city in order to have their case resolved.
A pilot with a foreign source income issue trying to litigate from Singapore or someplace like that.
Sure, we got pilots, you've got truck drivers, you've got people who travel a lot, and this has provided wonderful flexibility for them, and the technology is being put to good use. There's a lot that we can do over the telephone. So we're dealing with, you've got telephone conference calls. We're using Zoom Gov. That's the platform that we're using, and that's accessible on the computer, tablet, smartphones. So there's no real special equipment needed, and it's free to all participants. So we're seeing that it's expanded access. I think that it's making it a lot easier for people.
But aren't there some people who, with technology issues, not everybody even has a smartphone, that are encountering some problems?
Well, even if you don't have a smartphone, if you have a landline, we still have conference calls. We still have ways where you can move your case forward. And one of the significant things that we did is we modified our pretrial deadlines. So we used to have the pretrial memo sent to us 2 weeks in advance. Well, we increased that period of time to 3 weeks. And one of the reasons why we did that is that we wanted the judges to be involved earlier on in the case, so that the cases could be resolved earlier. In the past, when we had the 2 week period between pretrial memos and the actual trial, what would oftentimes happen is that when you got to calendar call, in many instances there were a lot of cases that weren't resolved because the parties hadn't met. They hadn't had any contact with each other, and they were getting together for the first time or having their first conversations at calendar call. So we expanded that period, and the judges are engaged earlier on in the process, so that we don't have those instances where where calendar call involves all these people coming, a lot of people coming who have previously haven't done any work on the case.
So more of the judges are taking more advantage of pretrial conferences?
Absolutely. That's a significant change in the way that the court as a whole is operating. Now, prior to this, many of the judges and I know I've always had a lot of conference calls before the trial session, because I found early on in my career that was a way to ensure that the parties were working on their cases. It also results in fewer unresolved issues at calendar call. So under the current procedures, we know before we get to the so-called calendar call, we know what's going on with most of the cases. And in many instances, calendar call just consists of calling cases where there's a motion to dismiss for failure to prosecute. But all the cases where there needs to be a trial and all that kind of stuff, that can, prior to calendar call, the trial dates and all that stuff can be set, so that the goal was to come up with a system where we couldn't have people meeting in courtrooms. It just wasn't safe. So in response to that, we had to come up with a system that eliminated the need for that. And by doing things remotely, it provided us with some opportunities to do things more efficiently. And of course, we didn't want to really replicate exactly what happens at calendar call, because there are some inefficiencies with respect to that. So we've changed things, and now a lot of what would typically happen at calendar call happens in that 3-week period before the session actually starts. And we've made other modifications to make that easier.
What about documents?
Well, the documents are typically received before the trial. We have, documents that are stipulated. We encouraged all of that to happen before the trial. But then we're also, we also make provisions for things to be filed during the trial. We leave the electronic filing system open so that things can be filed during the trial calendar. That was a change that we made. We also made some changes with our acceptance of limited entries of appearance. So now we have, taxpayers can get counsel earlier on in the process. If there are attorneys who just want to represent someone during this process prior to calendar call or just at calendar call, they can enter a limited entry of appearance and represent taxpayers for just pieces of their case.
But they used to have to do that at the calendar call. Right?
That's right. And the prior to that, the limited entries of appearance started at calendar call and terminated after the trial session. Well, now we're in a situation where it's just prudent and reasonable to allow those limited entries of appearance to be filed as soon as the case starts. So that's a huge benefit to the court, and and more importantly, it's a huge benefit to individuals who need counsel and need assistance.
I saw you recently added limited entries of appearance to the actual rules, so it's no longer just these announcement documents. So it sounds like that's going to be permanent.
Yeah, I certainly hope so. It's something that has really been really a big improvement to the system. And I must point out that our decision to allow limited entries of appearance, that issue was raised by the bar, and after we considered it, we had the various committees on the court take a look at it, and then we decided it was a great idea and adjusted and made some changes to the rules to accommodate it. And I think that the public is better served as a result. I would anticipate that as people get used to it, it's going to pick up in terms of the number of people who are using it. But it is an important addition to the way that we've been operating.
Speaking of permanence and getting back more directly to remote trials, what sorts of that stuff do you expect to last after the pandemic? Out of particular interest, the YouTube channel?
Oh, well, that's I think that's one of the wonderful things in terms of increased access. We have the availability for individuals to listen in on trials via YouTube, and if you are a tax junkie, you can listen to tax court trials while we're in session. You can wake up in the morning and listen to a New York trial, and then mid-afternoon you can listen to something in Chicago, and then later on you can listen to something in Los Angeles, and that's a significant thing. But in general, after the pandemic, remote proceedings are going to be a valuable tool in our toolbox. I mean, it took an amazing amount of effort to put us in the position we're in today, and I don't want to go backwards. I want to move forward. I don't want to simply return to the pre-pandemic state of affairs. We plan to emerge from this pandemic more efficient, more productive, more nimble, more flexible, and better prepared to meet our statutory mandate to provide taxpayers with a reasonable opportunity to appear before us with as little inconvenience and expense as practicable. So I think that as a result of these remote proceedings, we've got increased access to taxpayers that they may not live close to a place of trial, or in Los Angeles, even if you live close to a place of trial, it takes a while to drive into LA, or if you're in New York, you have to navigate some serious traffic issues in order to get to court. So by doing it remotely, we kind of address that problem. I would also hope that we'll see lower default rates as a result of the increased access and ability to just kind of sign on via Zoom. And I realize it doesn't have, some of the formality it's a little different doing it online, but it's still a court proceeding, and with all the rules that accompany it. But I think that the fact that it's online, that might make it a little easier for people to be comfortable and to present their case. So another advantage is that there's some cities we only go to once a year: in Anchorage, Honolulu, Billings, Montana, Aberdeen, Pocatello. We go there once a year typically. But now with remote proceedings, we have the ability to deal with those cases in more than just that one week that we've set aside. So that's significant too. So if we're in Alaska and we're only there in June or something like that, we can set a trial for later on in the year and not have any problems. And that's a big convenience to the taxpayer. In addition, for us, there are reduced expenses. There's greater availability of tax counsels with respect to the clinics. Now they're not limited to clinics that are in their area, but we can connect them with clinics that are in other parts of the country. So in that sense, it's a major advantage for taxpayers who need help, and not to even mention some of the other advantages that it may have. And one that I particularly enjoy is that it allows the chief judge to, on occasion, have a trial session. I do have difficulty finding time for it, but it at least opens that opportunity where I could have or whoever's chief judge can have an opportunity to travel to another location.
It's a perfect segue to basically my last question about feedback. You've had one, and also my understanding is the parties have feedback forms. So what sorts of feedback have you, in your experience, have the judges, have the parties given you?
Well, overall, the feedback has been very, very positive. But there have been things that you would expect that folks might have some concerns about. I mean, we've had comments about, well, I didn't hear the judge when he turned his head to the side, and there were instances where I couldn't hear very well.
When I've been listening, I've definitely heard some people are closer to their microphones than others.
Yeah. So there are things like that. We've had some instances where individuals have had difficulty connecting. They've had to walk them through how to connect. There's just standard things that everybody has run into when they're using Zoom. The common questions. Oh, I think you're muted. Little things like that. But these are all issues that are resolvable, and I think that as we continue, these are things that are going to be that we can address and address effectively.
Well, thank you very much for sharing your time with us. It's been a very interesting discussion.
Thank you, Nathan.
And now, coming attractions. Each week we highlight new and interesting commentary in our magazines. Joining me now from her home is Acquisitions and Engagement Editor-in-Chief, Faye McCray. Faye, what will you have for us?
Thank you, Dave. In Tax Notes Federal, Stanley Langbein argues that the IRS should withdraw Notice 2020-32. Andrew Weiner examines the Anti-Injunction Act, arguing that its purpose will be violated if taxpayers can challenge pre-enforcement tax obligations in court. In Tax Notes State, Rick Handel and Brittany Poole conclude their two-part series on the MTC's new draft statement concerning the ambiguities inherent in PL 86-272. Richard Cram examines recent Illinois legislation partially merging sales tax and seller-collected use tax. In Tax Notes International, Andrew Hughes begins a series providing transfer pricing benchmarkings that can be replicated by practitioners using readily available public data. Christopher Callahan examines the U.S. tax treatment of foreign pensions, retirement accounts, and Social Security programs. And on the opinions page, Nana Amasarfo discusses with European Member of Parliament Paul Tang some of his priorities as the first chair of the European Parliament's new subcommittee on tax. Ben Willis wonders, how does America address an unprecedented economic crisis amid a presidential transition?
You can read all that and a lot more in the pages of Tax Notes Federal, State, and International. That's it for this week. You can follow me online at TaxStew, that's STEW, and be sure to follow at Tax Notes for all things tax. If you have any comments, questions, or suggestions for a future episode, you can email us at podcast@taxanalyst.org. And as always, if you like what we're doing here, please leave a rating or review wherever you download this podcast. We'll be back next week with another episode of Tax Notes Talk.
Tax Notes Talk is a production of Tax Notes. You can learn more about us by visiting www.taxnotes.com/podcast. When major media wants the straight story, they turn to Tax Notes. Thank you for listening, and join us again for another edition of Tax Notes Talk. Tax Analysts, Inc. does not provide tax advice or tax preparation services. Nothing in the podcast constitutes legal, accounting, or tax advice. A full disclaimer is included in the transcript.